At 11:59 p.m. last Friday night, with 60 seconds remaining before the weekend, the Department of Justice filed an emergency motion in federal court. The target was not a terrorist cell. It was not a cartel kingpin. It was a retired federal judge serving as an independent watchdog tasked with reviewing and declassifying 2 million sealed documents related to the Jeffrey Epstein network. The motion requested immediate termination of the watchdog's authority, permanent sealing of all documents under national security classification, and seizure of all materials in the watchdog's possession. At 2:15 a.m. Saturday morning, in a closed hearing with no public docket entry, no advance notice, and no opportunity for the watchdog to respond, a federal judge granted the injunction. The independent review was terminated. The watchdog was fired. And 2 million documents containing flight manifests, offshore wire transfers, and financial links to sitting politicians and institutional power brokers were sealed permanently. Subscribe to this channel immediately, because what I am about to walk you through is not a bureaucratic procedural dispute or a routine classification decision. This is the Department of Justice using emergency legal authority at midnight on a Friday to neutralize the one person with the power to expose a syndicate that reaches into the highest levels of American institutional power. This is the justice system operating on two entirely separate tiers. One for ordinary citizens who face the full force of prosecution for minor infractions, and one for the elite, where the DOJ files midnight motions to ensure their crimes remain classified forever. Turn on notifications, set them to all, because the independent watchdog was scheduled to release preliminary findings Monday morning at 9 a.m. That release will never happen. The hard drives containing the wire transfer records have been seized under the Espionage Act. And while the DOJ was executing this midnight judicial coup, the Sunday morning political talk shows ran wall-to-wall coverage of a manufactured partisan feud over highway funding. They kept the public arguing over pennies while the system protected its owners. Here is the evidence. Because what the DOJ filed and what the fired watchdog has now leaked reveals exactly who this system exists to protect. Quote from page 4, section B of the DOJ emergency motion. Disclosure of these specific flight manifests and offshore financial transactions at this juncture poses an immediate and severe risk to national security and the stability of critical institutional operations. We request the immediate termination of the independent review. Read that language carefully. National security, institutional stability. Those are not legal terms. Those are threat assessments. The DOJ is not arguing that releasing the documents would endanger American lives or compromise intelligence sources. They are arguing that disclosure threatens the stability of institutions. Translation: the people named in those 2 million documents are so powerful, so embedded in the current structure of American governance and finance, that exposing them would destabilize the system itself. Quote, from the independent watchdog statement released Saturday morning after his termination, I was hours away from publishing the wire transfers. They didn't just fire me, they seized my hard drives under the guise of the Espionage Act. The names in those 2 million documents would collapse the current political establishment in 48 hours. That statement was not hyperbole. It was a professional assessment from a retired federal judge with 30 years on the bench and security clearance to review the most sensitive classified materials in the federal system. He reviewed the documents, he saw the names, and his conclusion was that publication would collapse the political establishment within 2 days. Here is what happened minute by minute between Friday at 11:59 p.m. and Saturday at 2:15 a.m. because the timeline reveals a coordinated institutional response to prevent disclosure. At 11:47 p.m., Friday, sources report that senior DOJ officials were in emergency communication with the Solicitor General's office, the National Security Division, and the Attorney General's Chief of Staff. The topic was not a terror threat or imminent attack. It was the independent watchdog's Monday morning release. At 11:52 p.m., a draft emergency motion was finalized. The motion had been prepared in advance, suggesting DOJ knew the watchdog's timeline and had pre-positioned legal arguments to block release. At 11:59 p.m., with 1 minute remaining before the federal court system's weekend closure, The motion was filed electronically. The filing was marked emergency, ex parte, and in camera. Ex parte means the opposing party, in this case the watchdog, was not notified or given opportunity to respond. In camera means the proceeding occurs in the judge's chambers with no public access. At 12:34 a.m. Saturday, the assigned judge, whose identity remains sealed, convened a closed hearing. Only DOJ attorneys were present. The watchdog was not notified. No transcript was produced for public record. At 2:15 a.m., the judge issued the order. The independent review was terminated effective immediately. All documents in the watchdog's possession were to be surrendered to DOJ custody within 6 hours. Any breach of the order would constitute contempt and potential violation of the Espionage Act. At 6:47 a.m., FBI agents arrived at the watchdog's residence. They presented the court order. They seized 4 external hard drives, 2 laptops, and a secure server containing the working files of the review. The seizure was executed under Espionage Act authority, meaning the watchdog is now legally prohibited from discussing the contents of the documents he reviewed. At 9:15 a.m., as Sunday morning political shows began their broadcasts, not a single major network mentioned the midnight DOJ motion, the termination of the watchdog, or the seizure of 2 million Epstein-related documents. Instead, CNN led with a segment titled "Outrage in Congress." Lawmakers clash over minor adjustments to the new highway funding bill. ABC, NBC, CBS, and MSNBC followed with similar coverage. The message was coordinated. Keep the public focused on partisan theater while the system executes institutional protection operations behind closed doors. Let me show you what was in those 2 million documents. Because the watchdog's preliminary findings, which were leaked to multiple independent journalists before the hard drives were seized, reveal a network that extends far beyond what the public understands about Epstein. The sealed documents include flight manifests for Epstein's aircraft covering a 15-year period. Those manifests list not just celebrities and tech executives, but sitting members of Congress, federal judges, senior military officials, and executives from defense contractors with multi-billion-dollar government contracts. The manifests are corroborated by customs and immigration entry logs, credit card transactions at international hotels, and offshore financial transfers that link Epstein's accounts to entities controlled by individuals currently holding positions of institutional power. The documents include wire transfer records showing payments from Epstein-linked offshore accounts to political campaigns, think tanks, university endowments, and charitable foundations that function as influence networks for policy formation. The amounts are not small. Individual wire transfers exceeded $10 million. Cumulative transfers to certain entities exceeded $200 million over a decade. The documents include communications, not emails, but encrypted message logs recovered from servers seized in the original Epstein investigation that reference specific individuals by name and detail arrangements for meetings, travel, and financial transactions that appear to function as a patronage system. High-level figures received access, financing, and institutional support in exchange for policy decisions, regulatory forbearance, or protection from investigation. This is not a sex trafficking case. This is a systematic corruption network that used Epstein as the operational hub for compromising and controlling individuals who hold power across government, finance, media, and academia. The flight logs are not evidence of crimes. They are evidence of leverage. The wire transfers are not payments for services. They are investments in institutional capture. And the DOJ just used emergency judicial authority at midnight to ensure none of this is ever made public. Here is why the DOJ acted with such urgency. Because the watchdog was not operating on a theoretical timeline. He had a specific release plan, and that plan was 48 hours from execution. Monday morning at 9 a.m., the watchdog was scheduled to publish a preliminary findings report. The report was 187 pages. It included 347 names, all cross-referenced with flight manifests, wire transfer records, and corroborating evidence from financial institutions. The report did not make allegations of criminal conduct. It simply presented the documented connections between individuals in Epstein's network with a recommendation that Congress open formal investigations into each case. The 347 names included 14 sitting members of Congress, 6 federal judges, 11 senior executives from defense contractors currently holding classified government contracts, 23 individuals serving in advisory roles to the current administration, and 47 figures from media, academia, and finance who shape public policy discourse. The DOJ's midnight motion was not about protecting national security. It was about preventing the publication of those 347 names. Because once the names are public, the questions become unavoidable. Why did these individuals travel on Epstein's aircraft? Why did they receive wire transfers from Epstein-linked accounts? Why did regulatory agencies with jurisdiction over their industries consistently decline to investigate? The system cannot allow those questions to be asked, because the answers would reveal that American institutional power operates through networks of compromise, leverage, and mutual protection that have nothing to do with democratic accountability or rule of law. Here is what we are watching for over the next 72 hours. 6 indicators that will tell us whether this midnight judicial coup can be sustained or whether the documents leak anyway. Indicator 1, does the watchdog comply with the Espionage Act gag order, or does he defy it and release information publicly? If he goes public, he faces federal prosecution. But if he believes the system is protecting a criminal syndicate, he may conclude that exposure is worth the personal cost. Indicator 2, do any members of Congress demand the unsealing of the documents and the full findings report? If senators or representatives with subpoena power call for disclosure, it creates political pressure that the DOJ must respond to. If Congress remains silent, it confirms that enough members are implicated to prevent institutional action. Indicator 3, do independent journalists who received leaked preliminary materials published despite legal threats? The watchdog shared files with multiple reporters before the FBI seizure. If those reporters go to print, the 347 names become public, even if the official report is suppressed. Indicator 4, does the federal judge who granted the midnight injunction face any scrutiny or challenge? If civil liberties groups, legal scholars, or judicial ethics watchdogs question the legality of a closed ex parte proceeding that terminated an independent review without notice, it creates a legal pathway to challenge the order. Indicator 5, do any of the 347 named individuals preemptively resign, recuse, or distance themselves from Epstein connection? If public figures begin stepping down from positions or issuing statements denying involvement, it signals they know the names are about to leak and are attempting damage control. Indicator 6, does the DOJ attempt to expand the Espionage Act seizure to journalists or outlets in possession of leaked materials? If the government moves to suppress publication through prior restraint or seizure of journalistic materials, it confirms the documents are as damaging as the watchdog claimed. Here are the 3 scenarios. Scenario 1, full suppression. The watchdog complies with the gag order. Journalists decline to publish for fear of prosecution. Congress remains silent. The 2 million documents stay sealed permanently. The 347 names are never released. The system successfully executes institutional protection, and the public never learns the full scope of the Epstein network's reach into American power structures. This is the outcome the DOJ midnight motion was designed to achieve. Scenario 2, partial leak. Some of the 347 names leak through independent journalists or whistleblowers. The DOJ cannot suppress all copies of the preliminary findings. Public pressure forces limited congressional hearings, but those hearings are carefully managed to avoid exposing the most powerful figures. A few mid-level individuals are sacrificed as scapegoats. The core network remains protected. This is the controlled damage scenario, where the system contains the fallout by offering limited transparency while preserving institutional power. Scenario 3, full exposure. The watchdog defies the gag order and releases everything publicly. Journalists publish the complete list of 347 names, with corroborating flight logs and wire transfers. Congress is forced to open investigations. Public outrage reaches a level where institutional protection mechanisms fail. Resignations, prosecutions, and systemic reforms follow. This is the collapse scenario, where the midnight judicial coup fails and the system's protection of elite criminality is exposed on a scale that cannot be managed or contained. What I know for certain right now is this. At 11:59 p.m. Friday, the Department of Justice filed an emergency motion to terminate an independent watchdog reviewing 2 million sealed Epstein documents at 2:15 a.m. Saturday, a federal judge granted the motion in a closed proceeding with no public record. The watchdog was fired, his hard drives were seized under the Espionage Act, and a preliminary findings report naming 347 individuals connected to Epstein's network, including sitting members of Congress, federal judges, defense contractor executives, and senior administration officials, was suppressed 48 hours before its scheduled release. The mainstream media spent Sunday morning covering a minor highway funding dispute while completely ignoring the midnight termination of the most significant corruption investigation in modern American history. The justice system did not act to protect national security. It acted to protect the institutional power structure from exposure. And the 2 million documents that could collapse the current political establishment, according to the fired watchdog's own assessment, will remain classified forever unless someone with access chooses to defy the gag order and release them anyway. This is not a case of one bad actor or one compromised politician. This is evidence of a systematic network that operates through leverage, financial control, and mutual protection across government, finance, media, and academia. The Epstein network was not a criminal enterprise that operated outside the system. It was a mechanism through which the system selects, compromises, and controls the individuals who hold institutional power. The DOJ's midnight motion proves that the system will use every legal tool available, including closed-door judicial proceedings, Espionage Act seizures, and permanent classification of evidence, to prevent the public from understanding how power actually operates in America. The watchdog was not fired because he broke the law. He was fired because he was about to expose the people who own the law. Stay with this channel, turn on notifications. When the 347 names leak, when journalists defy the Espionage Act threats and publish, when Congress is forced to respond to public pressure, you will see the analysis here immediately. This is not over. This is the Department of Justice executing a midnight judicial coup to protect a criminal syndicate embedded at the highest levels of American institutional power. And whether that protection holds or collapses will determine if the rule of law applies to everyone or only to those without the connections to make their crimes disappear.